Thank you very much, Chairman Grell, Acting Chairman Calderon. Thank you for those remarks. And members of the committee, we had a pretty long session week this week, so I appreciate all of your attendance here this morning, and interested audience members and the witnesses as well. I appreciate the ability to talk to you about my House Bill 79, which would affect a constitutional change to allow judges to serve to the end of the year in which they turn 75 instead of 70, as the current constitutional provision reads. This current provision has been in effect since 1968. 1968. There's people in the room who weren't born in 1968, okay? But I think many of us know that there have been many demographic changes in Pennsylvania and in our nation since that time. Not the least of which is, of course, that the life expectancy has advanced in that time from age 70 to 78. And it's no longer unusual, as per Chairman Calderon's remarks, to meet somebody who is living and working well into their 80s and 90s. Pennsylvania seems particularly blessed in that regard and has a large percentage of citizens in that demographic age group. For some of us who remember back to 1968, don't trust anyone over 30 was the mantra. Remember that? Okay, suddenly 75 doesn't seem as old as it did back in 1968, and retiring at 65 is coming to be viewed as retiring early. So my bill proposes moving the mandatory retirement age from 70 to 75 for judges. Other proposed legislation in the Senate would actually remove the age entirely. In other states, there is no maximum age at which one is allowed to serve as a judge, and other states still have retirement ages at 70, 72, 74, or 75. In Vermont, the hardy Vermonters are allowed to stay on the bench until age 90. The lawsuits, in fact, there are lawsuits, in fact, that are challenging the Commonwealth's mandatory retirement age of 70 as arbitrary or as a violation of laws prohibiting age discrimination. And these are all important things to keep in mind, but they're not the reason that I introduced the bill. For me, a person who has practiced law at least part-time for more than 30 years, I know and have seen many, many judges. I've practiced before judges in state courts in their 40s, 50s, and 60s, where when they reach age 70, they're allowed to be senior judges and continue in service. And they actually have to either retire or become senior judge. But I've also practiced in federal court where there are lifetime appointments, no upper limit. I've seen men and women in their courtrooms and in their communities, and I just have a hard time believing that on your 71st birthday, suddenly you're incompetent to continue as a judge. In fact, I think the opposite might be true. In his book, Outliers, that some of you have read, Malcolm Gladwell posits the theory that it takes 10,000 hours to master a subject, whether that subject is playing the violin or sinking a jump shot. And that's about 5 years if you're doing it full time, 5 days a week, 40 hours, okay? But think for a moment what it takes to master the role of a judge and what it means to have mastery in the field of judging. The job of a judge is very different from the job that we do as legislators. As legislators, we're called upon to write good laws, to advance civilization, to correct perceived wrongs in the current system, and be mindful of what our constituents would like us to do and what they expect. But at the end of the day, as we all know, it is not the most brilliant law that gets enacted, nor the most just, nor the cleverest law, as some of us find to our chagrin when we think we have a law that meets those criteria. In the end, it's simply the law that gets 102 votes in the House and 26 votes in the Senate. That's a very different job than being a judge. And I should say also one that the governor's willing to sign. A judge by contrast, is sitting in judgment on a specific set of facts and specific individuals or businesses, and who is then tasked with applying the law to this specific set of facts. The judge doesn't write the law. He's supposed to know the law or look it up before he makes his decision, okay? But his decision applies to those people who stand in front of him in the courtroom, anxiously awaiting the decision. The judge has to make a decision that's based on specific people, specific testimony, specific evidence. The legislator's worried about the fate of the Commonwealth in general and his or her constituents in general. The judge is concerned about one citizen and what will happen to them as a result of the decision they make. But so it does seem to me that whether we're talking about a legislator or a judge, the nature and extent of the human experience matters. And if it were not so, a well-programmed computer could do either of our jobs. But it can't. Drill down a bit and think about these situations which judges deal with every day in the Commonwealth. In deciding the custody of children, let's say aged 4 and 6, would it not be helpful for the judge to have some experience with people of that age? In determining whether a son is protecting a mother from her own frailties, in minding her money for her, or in taking advantage of her in her frailty, would not some experience with a frail elderly parent be a useful thing for the decision maker in looking at those facts? In parsing a knotty question of title to real estate, or just the mineral or other rights in real estate, wouldn't experience in handling those cases be a helpful thing in making a decision? Even in trying to persuade lawyers to settle a case, wouldn't experience with difficult personalities, and I say that as a former litigator myself, or even experience with the particular litigators who are in the room, be a useful thing in trying to get them to come to a resolution? For understanding veterans, isn't it a good idea to have a judge who's served in combat or understands combat to be able to judge their unique situations? I think the answer to all these questions is yes, and I think it means that experience matters in doing the job of judge. At my law firm, my senior partner, Tom Timoney, namesake for Timoney Knox, which is our law firm, practiced until a couple of weeks before his death in his 80s. He was not only the go-to guy in our law firm for trust and estates, which is what he was an expert in, having practiced for more than 50 years, but he was also the go-to guy for just about everything else. In other words, if you had a brother and a sister fighting over whether to pay for a headstone for mom's grave, Tom Timoney was the guy who would tell you how to get them to agree. He had spent 50 years practicing law, 50 years married to the same woman, 50 years raising 9 children, and he had a wealth of interpersonal experience that helped him make good judgments about what should be done. I think in the later years, lawyers like Tom Timoney have those experiences fermented so they become wisdom in practice. In my own home county, Judge Horace Davenport, the county's first black judge, was a master at settlement conferences. His percentage at settling cases was better than any other judge on our court, and he only left when the law required him to do that. And as a result, the court's backlog grew a little bit because he was not there to do his job. Now, I know that some people will worry that an increasing percentage of older judges, as an increasing percent of seniors, might be afflicted with conditions like Alzheimer's or dementia or other things that would affect their ability to be effective judges. However, I do not believe we need a hard and fast rule that bars everyone over the age of 70 from serving. That's why we have a Judicial Conduct Board, consisting of judges, lawyers, and citizens who can investigate complaints and accord a judicial discipline. Each of these bodies deals with specific complaints, investigations, specific judges, and determines whether or not they should be on the bench. The current mandatory age of retirement at 70, by contrast, simply throws the baby out with the bathwater, ridding the court of wise, older judges who may have become better with age, along with those whose abilities may have declined. As Rabbi Harold Kushner, author of many influential books, put it, we do ourselves a disservice when we make old age something to be feared. Life is not a resource to be used up. So the older we get, the less life we have. In fact, life is an accumulation of wisdom, love, experience, of people encountered, obstacles overcome. The longer we live, the more life we possess. House Bill 79 stands for the proposition that mere age alone is not a disqualifier if the human being selected as a judge is otherwise competent to be a judge. In fact, if we want wise and just judges making the right decisions for the individuals who stand in front of them, we just might learn to prize their extended experience and the wisdom that it brings. Thank you.